Hello, everybody. My name is Julia Nakamura. I'm a PhD candidate with the University of Strathclyde's Law School, affiliated with the Strathclyde Center for Environmental Law and Governance, and also an international legal specialist with the Development Law Service of the Food and Agriculture Organization of the United Nations. And I'm here to present on unlocking legal and policy frameworks for small-scale fisheries. This is part of the TBTI training workshop. I hope this will facilitate your work on assessing and filling in the templates that we have shared with you. This presentation will go through context. We'll present the context, and then we'll highlight some key points that are relevant in your assessments, clarify some key concepts, and give you some tips on where to start. Here I present some acronyms which you may be familiar with, but just in case you're not, these are relevant to know. So the context, it is always important to recall on the evolution of international law throughout the past century. And I guess, you know, even though fisheries is a millenary activity, has been so important since its existence, there has not been an international instrument adopted at the global level with a universal membership, not up to 1982. States have been very reluctant to subject their sovereignty to international law when it comes to how they manage fisheries. And it took a long time. The negotiations started in the 1950s, and only in 1982, they finally adopted by consensus on this instrument, which is up to date, the main primary international instrument governing the oceans. It's considered the constitution for the oceans for this reason. It has set out rules for each maritime zone, you know, including the territorial sea, contiguous zones, exclusive economic zone, and the high seas. And for fisheries, that meant also that was very important, because in the exclusive economic zone, states had to comply with requirements with respect to total allowable catch, best scientific evidence for setting out conservation management measures, and so on. And generally, the protection of the marine environment is required in any maritime zone. So the Law of the Sea Convention is definitely a landmark when it comes to governing the oceans, but still is limited with respect to addressing fishers and small-scale fisheries. There's a lack of provisions on that regard. So the 1995 Fish Stocks Agreement, which is one of the implementing agreements of the convention, has addressed conservation and management of highly migratory fish stocks and straddling fish stocks, and has to some extent addressed small-scale fisheries, but into that particular context. And the FAO Code of Conduct for Responsible Fisheries as well have addressed small-scale fisheries in various terminologies, you know, artisanal, subsistence, local communities, indigenous peoples, that really varies, and that was not sufficient and clear enough to address all small-scale fisheries issues. So that has only really came about with the 2014 FAO Voluntary Guidelines for Secure and Sustainable Small-Scale Fisheries, which is shorter title for, you know, FAO SSF guidelines, and has since then, of course, stimulated the work, the increasing attention given to small-scale fisheries in the international fora, and more importantly, because it has followed a human rights-based approach, highlighting the human rights and the rights of fishers, which usually you wouldn't find in a fisheries instrument. So that was quite unique. And it stimulated the work at regional levels, such as with the Latin American Parliament's Model Law for Small-Scale Fisheries, which was endorsed in 2017, as well as in forums that are outside the fisheries domain, so in the United Nations Human Rights Council adopted as well the Declaration on the Rights of Peasants in 2018, which applies to small-scale fishing communities. So this discussion is very important. So just to give some overview on the process of developing the SSF guidelines, it began in 2006 with the United Nations General Assembly setting on the mandate of FAO to develop guidelines for small-scale fisheries. And that, of course, followed by various meetings, studies, and research on, it sort of stimulated more the debate on small-scale fisheries. And in 2011, the Committee on Fisheries approved the development of this new instrument on small-scale fisheries, which then, there were more consultations to ensure that the process was participatory, inclusive, and really reflected the interests of small-scale fishers and the communities. So in 2013, there was a multi-stakeholder technical consultation to agree on the final text, which was resumed in 2014. And finally, the COFI's 31st session, the members endorsed the SSF guidelines in June 2014. And since then, of course, the debate has always been about implementing it and how to put that into operation, how to walk the talk. And there has been a lot of studies, a lot of contributions, as Ratana explained on the book of how to implement the SSF guidelines by different countries, but yet there has been still the need to better understand how law and policy can contribute to implementing the SSF guidelines. And this is very important so that we can have better understanding and can really contribute and celebrate in 2022 on the International Year of Artisanal Fisheries and Aquaculture, and really have a better understanding of how to implement the SSF guidelines through law and policy. So some key points that you have to consider and bear in mind when you're doing your assessments is that this is all about really understanding and improving our knowledge on how small-scale fisheries is captured by legislation and policy. It's a matter of reporting really what you find. If legislation is old legislation, that this is what the country provides, and if it's a policy that is also old, this is what your country provides. It's about trying to define which instruments we are looking at, which is legislation and policy, and trying to understand how they address small-scale fisheries, if there are any differentiated treatment given to small-scale fisheries, if small-scale fisheries are specifically referred, and what are potential gaps that you can find, or insufficient provisions. Clarify which rights are secured by legislation, if it's tenure, access, human rights, and roles and responsibilities that are provided so that small-scale fishers are represented, their participation is ensured in decision making, their duties are well delineated. So just to have an idea and put that into more concrete terms, we have found some provisions that I find useful, and that these are the provisions that we're looking for if you have those. In the Gambia Fisheries Act of 2007, there is a provision that ensures that one representative over the artisanal fishing sector is part of the Fisheries Advisory Committee. So that is very important to ensure the representation of the artisanal fishing sector in a governmental body. In Ghana, for instance, the Fisheries Act of 2002 provides that the part of the monies of the Fisheries Development Fund is allocated to assist small-scale fishery cooperative enterprises. So this is another way of ensuring that you have part of that money, which is already very, very important for the development of fisheries, allocated specifically for small-scale fisheries. You can also have exemption from duties that may be too costly for developing countries. If you impose a requirement to go fishing that you have to have a vessel monitoring system on board that, that is too costly, and they may not have that technology. So for artisanal fishing vessels in Cabo Verde's legislative decree of 2020, it has exempted artisanal fishing vessels from that obligation, which facilitates the access of artisanal fishing vessels to go fishing. The same with Peru's Supreme Decree of 2001, which exempted artisanal fishers from the payment of fishing rights. So if they don't have to pay fishing rights to go fishing, that's also a facilitator of access of small-scale fisheries to their fishery resources. Another interesting provision was found in Algeria's executive decree of 1996, which provides for an exclusive zone extending up to 3 nautical miles reserved to small-scale fishing vessels with capacity of no more than 50 gross tonnage. And we found more provisions of other countries that reserves a specific area to small-scale fishing, and that is useful, to protect small-scale fishing from other competing activities. But that, of course, always bear in mind that small-scale fishers have to sustainably manage those resources, because if you're giving a limited space for small-scale fishing, then the resources also needs to be there and need to be resilient, and they can't over deplete deplete those resources by fishing unsustainably. So it's always a matter of balance of rights and duties. And we found more examples. You can find in this link here down where you can find more examples of these provisions that we found in both legislation and also references in policy. There are some key concepts that it's always important to reinforce, and they are well explained in this literature that in the second column here. If you're interested in better understanding more and sort of getting more used to these concepts. Small-scale fisheries is, of course, a very complex and dynamic and diverse and context-based concept, because it speaks to so many different terminologies. And you usually find artisanal, subsistence, semi-industrial, coastal, indigenous peoples, aboriginal fisheries. That would really depend on the country. And if you're looking, I think what's relevant as well is to look at the people that are behind the fishing activity. If they're, of course, artisanal fishers, but if they're mentioned in a policy or legal instrument as indigenous peoples or women, children, migrants, peasants, they are all vulnerable groups who are engaged in fishing, and therefore, fall under that vision that we have of small-scale fisheries. Human rights and related rights, that's very broad. And we know, of course, that human rights and related and are stemming from international human rights standards and the United Nations Universal Declaration on Human Rights, the International Covenant of Economic, Social, and Cultural Rights, International Covenant on Civil and Political Rights, and associated protocols. So these are well defined in international legal instruments. The right to work in just and favorable conditions, the right to social protection, the right to education, the right to adequate standard of living, the right to freedom of movement, etc., etc. And these are usually fundamental, and you will find in Constitution, because these are so fundamental rights that they will be recognized in Constitution, and sometimes even the right to a healthy environment would be there as well. But you can also find in different specific legislation, which will not be the fisheries legislation. So important to have in mind, to bear in mind that it's not only about fisheries legislation, but other legislation can support your answers. Tenure rights speak to this idea of access to resources on land, adjacent land, and sea. So we have, of course, a formal system, which is provided by legislation, by regulation, which ensures that the requirements that are clear you have to be registered as a fisher. You have to register your fishing vessel, your fishing gears. You have to apply for a license, and you have to fill in a template to apply for this license. And this license will establish your rights, your tenure rights. So where can you fish, the amount, the allowable catch that you're allowed to fish, the quotas, the space, the time as well, the temporal control. So it will really vary, and it will depend on the legislation. But this is how a legislation will provide for tenure rights, through a licensing scheme or an authorization or a permit, depending on concession of rights. You can also have that in an informal customary system, which is not regulated by any formal instrument. So that is an interesting aspect to look at. In some countries, you have recognition of customary rights. I've seen in the Solomon Islands, the Fisheries Act recognizes customary rights, but that would depend on the country and whether this is recognized through a formal legislation, or if it's not, if it's the common practice of a community. All this has to be informed in your answers, and really, just inform what it is, irrespective of being formal or informal. The ecosystem approach to fisheries is a principle, a strategy that's the origins of the ecosystem approach dates back to the 1971 Ramsar Convention on the wise use of wetlands, but it has evolved throughout time, and mostly through the Convention on Biological Diversity regime. But when it comes to fisheries, there was a declaration, the 2001 Reykjavik Declaration on Responsible Fisheries in Marine Ecosystems. That was, pretty much where ecosystem approach to fisheries started, and it has been implementing, as to ensure that when you're fishing, you're not considering only the targeted species, but the impact of that fishing on associated species, related species, dependent species, habitats, ecosystems, and so on. So everything is sort of integrated, and you want to make sure that the integrity of ecosystems are maintained and they're balanced. Gender, you would find a differentiated treatment to women, because this is part of the vulnerable groups. And of course, women in fisheries and in small-scale fisheries, they are very important. They represent, in many developing countries, half of the workforce, and they need a special protection, because not only they're vulnerable, they are sometimes doing double shift works, working at home, working in the field, and so there needs to be a special protection, and you would find that in national policies for the protection and empowerment of women, but also sometimes in some countries you would find legislation specifically for addressing women, this protection, and that would be something to consider as well, of course. Labor rights, they are also related to human rights when you're talking about decent work, and prohibition of slavery or forced labor. This is more related to human rights, but you also have labor rights stemming from the labor law, and some requirements that you have to meet in order to have a professional identity, and have the right to and have a cooperative, or engage, or be entitled to associate, so to be in an association or a cooperative or any other professional organization for fishers. Climate change and human-induced disasters, they're very related, because it's all about how you prepare for those impacts, and how you adapt and how you mitigate. So when it comes to small-scale fishers, they are of course vulnerable, and they need financial assistance. So you would expect that a climate change policy would have funds that would be addressed for fisheries, and this is how there may not be a specific reference for small-scale fisheries, but if you have a policy or a legislation that ensures that funds are guaranteed to local communities or coastal communities, or small-scale fisheries in general, then you can argue that it could be applied to small-scale fisheries. So a few tips on where to start. Which instruments are we talking about? We are here looking at law and policy, and we know that this can be very diverse depending on the country. And the types of legislation that you may come, the types of legal instruments that you may come, across can vary from, the constitution, which is usually the primary fundamental law of a country, and then to a primary act, a primary legislation, which can be an act, a law, a code, a statute, or ordinance, as well as the secondary legislation. The type of legal instruments doesn't really matter as long as it provides the information that you're looking for. But just so you have an idea, if you're looking at the Fisheries Act, the Fisheries Act would provide the general framework. So the main elements for fisheries management and development, and development not so much, more fisheries management. So licensing, access and control of fishing operations, types of gears, management controls, surveillance, monitoring, and sometimes procedures. But it's like a broad framework, and then you would have a decree or a legislative decree, a secondary legislation regulating that primary act. And it's much more rigid, so you wouldn't, you may find some amendments and some repealing of legislation, but that would take more time. Policies, instruments, instead, they're much, they change over time with more frequency, because they are, usually for a 4 year time frame. So they're more flexible in that sense, and they would usually, when it comes to fisheries, a fisheries policy would provide the overview of the fisheries in the country, and then would state the problems, the issues that the country faces, and then what are the strategies of the country with respect to targeting those issues. And you would expect that throughout time, you would have an evolution of those issues that are being treated, and hopefully considering small-scale fisheries in more recent policies. And this is what you would want to find. Some examples of these types of legal and policy instruments. So in this article that I wrote with Professor Fabio Hazin, we identified already some important, we found important information on Brazil with respect to issues that the SSF guidelines call for. And in the federal constitution of Brazil, for instance, you have specific provisions that address small-scale fisheries. Again, small-scale fisheries in Brazil fall under artisanal fishers, the reference to artisanal fishers, and or just fishers in general. So these two provisions, one is particularly addressing artisanal fishers and the right to benefit from social security, and the second one is more general to fishermen and fisherwomen and their retirement pension. So just so you see, like, even if it's only a fisher, only referring to fisher, that's also, of course, applies to small-scale fisher. And the National Fisheries and Aquaculture Law and Policy of Brazil refers to many different terminologies when it comes to small-scale fisheries. And that is what is interesting to see, because, you may have reference to artisanal fishing, non-commercial subsistence fishing, small-scale boats. It will really vary. And what we found is that this main fisheries and aquaculture law and policy does not address many of the SSF guidelines issues, and that is to be complemented by other federal legal instruments, such as some decrees that we found on policies for women, for instance, on traditional peoples and communities, coastal management, and even other legislation on nature conservation units, for instance. So the tips on where to start: you have to ensure that the legislation you find is valid, is enforced, if there are any amendments. So in the FOULEX database is quite straightforward. You find when the legislation is revoked by another one. This is provided there, but just to make sure that you have everything very updated, you can always check on your governmental website or in other sources whether this legislation is valid, is enforced, and always making sure to read the legislation with the amendments, because unless there is a version of a consolidated version of the law, which provides, all the amendments up to a given year, you have to literally look at the legislation and the amendments to it, and make sure that, what is the provision that is enforced and valid, and make sure that the policy is current. But it could be, that a government has not updated a policy, and the latest policy that you have access to is a policy from 2013 or even before that. That's not a problem. As long as you provide that information, look, this is the latest policy I found, and make sure that, this is the most current one. It is what it is. And check how small-scale fisheries is addressing these instruments. So whether it's generally, if it's only fisheries, if it's only fisher, that is enough to cover small-scale fisheries. In some countries, we know that most of the small-scale fisheries, most of the fisheries workforce are coming from small-scale fisheries. So why, in the head of the legislature, why differentiate, small-scale fisheries from industrial fisheries if all the countries' fisheries are coming from small-scale fisheries? So if it's generally, that's enough to cover small-scale fisheries, and all these provisions are relevant for small-scale fisheries. If it's specifically, then it's even better, it's even more important, and you have to then highlight those provisions that are specifically addressing small-scale fisheries. And you will then analyze whether these selected provisions or parts supports the questions in the template. Thank you very much for your attention, your interest in this project, and I'm happy to clarify any questions. Please do send a message and questions if you have any. Thank you very much, and bye-bye.